Assalamualaikum and hi. As an introduction of Escort et al. Versus Bakri Constructions Corporation 1968, this case involved a bowling early construction business, Bakris, who filed a false registration form, and a class of the debentures buyers who then filed suit against the audit firm under the Securities Act of 1933, and at least 8 parties involved as the defendant.
The fact of the case is plaintiff's claim against defendant corporation to recover damages under Section 11 of the Securities Act of 1933. It is for a false registration statement. Intervener debenture holders filed a motion to intervene. The trial court denied the motion and interveners sought review of the order.
Let me explain about liability of the auditor. The auditor has a duty to employ such skills with reasonable care and diligence. But for this case, they fail to observe its own internal standards. For example, in this case, he had no plausible foundations for trusting its included mistake or missing information section outside his pro-efficiency.
For the auditor defense, the case having implemented due diligence when formulating a registration statement of Bakris, which is a defendant. Multiple principals and professionals involved seek protection under Section 11B but motion denied due to lacking of ample diligence. Thus, all parties are liable in this case.
The concepts highlighted in this case is a registration statement was created which contains abundant mistakes such as exaggerated sales, net income, and earnings per share, but not revealing unpaid debts, customers' behaviors, and others. Auditors of Bakris, Pitt Marwick, did not obtain accurate registration statement due to improper conduct of investigation.
In conclusion, the Section 11B protection is not afforded to any of the parties involved as stated the reasons for each party in this slides. The audit firm on behalf of Bakris was found liable in this case on the grounds that they had not established due diligence requirements under the Act. Now, let's move on to the next case. Hochfelder versus Ernst & Ernst. This case involved Hochfelder, who sued for damages against the accounting firm Ernst & Ernst because of the careless non-feasance in failing to uncover the mail rule imposed by the presidents of First Security Lester Ney.
Facts of the case Hochfelder versus Ernst & Ernst is Ernst defendant and accounting firm failed to expose an escrow account fraud plan committed by the president, causing Hochfelder plaintiff seek damages for negligence under Section 10B of the Securities Exchange Act of 1934. Civil damages fails to fall under Section 10B of Securities Exchange and SEC Rule 10b-5.
In this case, the auditor, which is Ernst & Ernst, is not liable for negligence, bad faith, or dishonesty, and for mere errors in judgments. This is held by the U.S. Supreme Court that Hochfelder claimed damages from Ernst for its careless to uncover the mail rule made by Lester Ney. Apart from that, Ernst has failed to conduct proper audit and provided an unqualified audit opinion.
For auditor's defense, generally one can be held liable under Section 10 and Rule 10b-5 if they intentionally or recklessly mispresent information intended for third party. In this case, the Supreme Court ruled that scienter, which is knowledge and intent to deceive, is required before auditors can be held liable for violation Rule 10b-5.
The auditor has a duty to employ such skills with reasonable care and diligence. But for this case, they fail to observe its own internal standards.
To conclude, the actions for civil damages fails to fall under Section 10B and SEC Rule 10b-5 on the grounds that negligence alone is inadequate to file the suit.